Absolutely, I'd love to. So there are a lot of ways you can look at this issue, but for us at our firm, we break down the litigation process into 6 stages. First, before the pleading stage, is a time to investigate the case. Get all the evidence, get ahead of the other side, know what the documents look like, and know how to plead the case. Then you go into the pleading stage. Pleading is essentially a court document that sets forth the issues. It's the theories that the plaintiff is going to rely upon at trial. So you got to get those right, and it's important to get them right. You may be able to trigger insurance coverage without a certain cause of action you wouldn't be able to. You may be able to allege a cause of action, such as fraud, that allows for the recovery of a different type of damage. After the pleading stage comes the discovery stage, and this is the investigation. Interrogatories, subpoenas, depositions. It's where the parties gather all the evidence, and you get the evidence you want to use at trial to win, and you want to get the evidence excluded that the other side wants to use at trial. After the discovery is all brought together, there's a time when the parties may want to file what they call dispositive motions, and that's where you ask the judge to throw the case out, or some of the case out, or maybe one of the remedies out. So this is a big deal. They're usually defense motions. You need to prepare to oppose those. After the dispositive motions are heard, there is an opportunity, usually in most cities, large cities, where the judge will order the parties to go to mediation. And that's just a place where you can go to sit down with a professional and try to resolve the case without a trial. If that fails, then you're looking at trial. So trial, you pick a jury, maybe it's a judge trial. You put on your evidence, you argue your case, and the jury decides it. After the jury trial, a verdict comes in, and it can be a judgment entered by the judge thereafter, but there's always the opportunity to appeal, and that's the last thing that would happen in a court case. So you can appeal to a court of appeals all the way up to the United States Supreme Court. Ultimately, there will be a final judgment, and that's how you do it.